Welcome to the tense courtroom where the judge's patience is wearing thin. A report with an unprecedented history of non-compliance, failing to meet the conditions of the exception, along with a recent positive drug test, nearly 1,000 days into extended supervision, has brought this crucial hearing to the stand. Now the question looms, how will the judge respond? Stay with us as the courtroom decides.
I guess Roxanne's not here.
She said that. It did tell me alcohol or THC.
He's still using. Unacceptable. I mean, I tested you once, you test positive, you test it again, you're still testing positive.
Judge, do we know the quantities and is it just THC? My client says he has not been smoking and I don't know how long it takes for it to come out of his system.
This case has been open since 2022. He's multiple times failed to appear. I've asked him to continually comply with bond conditions, and you've continually over and over and over and over failed to comply. Now your case is 1,010 days old, and you continue to test positive. Right now, you're going to jail. Goes with you. Unacceptable, Mr. Escamilla.
I've not been using.
Test says otherwise. And now at 1,000 days old, multiple tests, you stay with me.
Judge, and to be clear, I just got appointed last time. I haven't been on this case for 1,000 days.
You're
So,
not the first lawyer on this case.
I know, but
And at some point, we have to say when. But it's unacceptable that being 3 years old, and now it's over and over.
I think the issue is, Judge, he smoked before the last appearance when he was brought in on the warrant, because he's brought in on a warrant on the new charge. And I think that's the issue. I truly
Given
do.
the sufficient
And so-
amount of time.
I know, Judge, but just for me to advocate
I get it.
completely for my client,
I'm
I
never,
know he was on a warrant. I know that he was on bond for that first charge, but I think it didn't really sink in until the second one. And I've been in contact with him. My staff's been in contact with him. He's trying this time. So what's
no,
the,
and he's going in.
all right, what's the new bond? I'm appointed judge.
I get it.
I know, so he can't,
Tell
I know,
him that we mean business.
I know, Judge, I'm just
First case is
advocating.
at 5,003, so I'll set that at 7,504, and then 5,001 on the failure to ID.
Say that again, Judge, I'm sorry. And that's my hearing issue.
So the failure to ID is set at 1,000.
Okay,
So on that one, I'm going to do 5,001.
okay. And then the old case,
The old case is at 5,003, so I'll do 7,504.
7504. Thank you, Judge, I'll go talk to him.
4 projects are on hold. The entire order has come under fire. And now the judge's battle has reached a standstill. Witness the moment when the judge delivers a final, uncompromising verdict, refusing to accept any middle ground. Will the retaliatory evidence face the consequences for its actions? Watch this tense hearing to find out.
So the agreement that you guys have worked out is he's got 4 open cases?
He has 4 open cases, Your Honor. The agreement that we worked out was a time served on the failure to ID and the latest criminal trespassing, and they're dismissing a criminal trespassing and interfering with it.
Why, you need to understand something, that you guys can work something out. I don't have to accept the deal. And I am extremely upset with you at this point because I ordered you to get a device. You did not get the device, did you?
I'm sorry, I thought I was actually calling. I didn't know where to get it from.
I told you to get the device. I ordered you to get the device. You did not do anything. And now you are here on a bond violation, not to mention 4 open cases. And now you want me to just take a proverbial slap on the wrist? No. You need to understand, Mr. Musadaki, that actions have consequences. And
Yes, sir.
you not only picked up 4 cases,
I brought my dad here. He's here. Can you come with something?
your dad has nothing to do with this and will not save you from this. You have 4 cases and you failed to over and over and over to comply with bond conditions. I will not accept this agreement, and I am now revoking your bond, and you will go to jail. Goes with you. Unacceptable. Unacceptable. You need to learn that actions have
I've been working,
consequences. You today go to jail.
An emotional courtroom moment. A mother pleads to protect her son just before he's accused of setting a car on fire and stealing it. Now the judge faces a difficult decision. Can the law protect the community and give this young offender a chance to make things right? Is a mother's love powerful enough to sway the scales of justice? Watch this gripping hearing and see the battle between compassion and the law unfold.
Are you here with someone today? Are you mom? Come on up. You are mom.
I know.
Okay, thank you so much for coming.
Absolutely.
Mr. Patrick, you're charged with burglary of a motor vehicle. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge.
Oh, I have to give you a cause number. There's a warrant because he missed court. 255-9022.
2, 3. Is it?
No, it's 255-9022.
Yes, sir. 2, so. Judge, on April 7, 2025 in Harris County, Texas, officers were dispatched to a burglary of a motor vehicle call. The defendants were located and matched the description the complaining witness gave to the officers. The complaining witness stated defendants entered the vehicle and tried to steal it by breaking the ignition cover. The complaining witness stated her neighbor was leaving for work and it scared the defendants off. The defendants left a screwdriver in the motor vehicle. The complaining witness stated that the ring camera at the audience, the co-defendant was found to have 2 key fobs on his person, and both key fobs belonged to other individuals. The screwdriver and gloves were found in the defendant's backpack, and a ski mask was found on the co-defendant's person. The defendant provided false information, and the defendant was eventually identified by mobile AFIS.
There's so many holes in this thing. I mean, how do we know it was him? Was he in the car? Where did they catch him? Did they go running after him? I mean,
Judge, if I can just.
it's a complete disjointed submitting now.
Judge, the law enforcement officers were dispatched and were given a description of 2 individuals by the complaining witness who had it on a ring camera of the individuals breaking into a vehicle. And
Did they see him? Does the report say that they saw Mr. Patrick?
just a description given, Judge. And then the law enforcement officers on dispatch located the 2 defendants nearby.
Does it say that there, or are you assuming?
To a burglary, they advised the last direction of travel being east of the residence and northbound intersection of Maryland. After a brief search, both defendants were obtained on foot, matching the description provided by one complaining witness. The complainant advised that they made entry into a vehicle and advised they attempted to steal the vehicle by breaking the ignition cover. Due to a manufacturing flaw, upon exposing the ignition, the vehicle can be started without the ignition key. The complainant advised her neighbor directly across was leaving for work, and both defendants began to leave on foot when they heard noise. And then they found a screwdriver was found on the vehicle floorboard. The complainant advised that her doorbell camera captured the incident and provided a positive description of both suspects, both being males wearing dark hoodie sweaters, black pants, both slender in build and being tall, and one being tall and one being short. After a pat-down search of the defendant, defendant 2 was found to have 2 key fobs stuck into his pants, and one fob belonged to a Dodge that was connected from another burglary of a motor vehicle. That was not the charge you'd be here, Judge.
Is Mr. Patrick defendant 1 or defendant 2?
He's defendant 1, Judge.
He doesn't have the key fob. It's the other gentleman.
That's correct, Judge.
He's the one that has the stuff in the backpack.
Just want to verify that, Judge. That's correct.
Patrick, I'm going to find that there's probable cause to go forward with your case. You live in Houston, dude. You don't live in another state. People like their guns and they like their cars. And when you mess with the wrong person, they're going to shoot your ass dead in a heartbeat to keep what's theirs. How many countless stories do you hear of someone running away from one of these types of situations? They get shot in the back. It's only a matter of time. Was this in the middle of the night?
It was early in the morning, Judge, around 6 a.m.
Patrick, I'm going to find that there's probable cause to go forward with the case. I am now going to put a whole host of conditions to make sure that you do not fall through the system or the cracks, because we don't need another statistic or we don't need another person dead. Do you understand me? The first is that you are not to hang around with the co-defendant in this case. You are not to use alcohol, illegal drugs, and I'm going to send you for a test right now because I want to know what, if anything, is in your system, and you're to come right back. Do you understand? If you fail the test, if you fail to come back, it's not going to go well for you. I'm now also going to put a monitor on your ankle so I know where you are at all times. One false move, you will stay with me. I need your help, Mom. I can't do this alone. You and me together, we can make this thing work. Tell me about it. What does he do? Is he in school now?
Well, yes, he's school, so he did go to school. But
Okay. Wonderful.
he did have sign up for a job, so he was looking for a job, so he do have a job.
What I was going to do is I was going to order him and only give him time so he can go to school, and then he goes back home. And then he stays at home, doesn't go anywhere else. I don't want him out in the middle of the night. You're not to be in possession of any weapons as well. If I find that you have any weapons, if I find that you pick up a new case, it's not going to go well for you. I will protect my city at all costs. I don't care what you are, how old you are, anything. Do you understand? We will work with you to make sure that everything works together. I'm going to pay for everything so you won't have to pay for anything. I'm going to give you a lawyer today. So we just need to know what schedule. Do you work?
I work on Wednesday through Saturday.
And then you're out.
Then I'm off.
I mean, you're out like out working. My only fear is that when the cat's away, the mice will play. So that's why while you're at work, he stays at home. I'm going to test you like crazy to make sure that you're not using anything. Do you understand? You must stay in school full time. The GPS monitor will tell me where you are at all times. And if you leave school, try to skip class, I'm going to skip your bond. Do you understand? Okay. Shoot.
So, just a couple of years on, so him that, you don't have to come to me right now, because we're not going to work for him. So, yeah, I wish to,
Okay, so let me get you a lawyer. We got to figure out a schedule because I don't want him out just hanging around and doing whatever. If he gets a job, then we can work with a schedule. But other than that, I probably just got to stay at home. You know, I don't want him out just screwing around because, you know. Okay, we'll work together. You must listen to Mom. If Mom tells me that you start acting like a knucklehead, you will stay with me and you will earn your degree with me behind bars. Do you understand? If she tells you to jump, you ask how high. Do you understand, Mr. Patrick? Okay. All right, Mom. Please, just hang tight and then we'll hook you up. That way.
The judge could barely conceal a glimmer of hope, facing a repeat DUI offender who had already broken his promises to the court. This time, not just one, but 2 DWIs hang heavily over this man's record. Is there a limit to the court's leniency? What firm legal actions will be taken to stop this dangerous pattern? Stay tuned as the final verdict is revealed.
I don't see an ice hole.
I don't see legal. It's arraignment, black spot violation.
what? What's the case?
It's 253-7967.
Bail order or a no driving affidavit. It'll probably auto for tomorrow.
Bueno, señorita.
I don't know that.
Bueno, con la señora.
No,
Morning, Mr. Hernandez Ramos.
I'm sorry, what is,
Good morning, Mr.
buenos
Hernandez
días,
Ramos.
señor Hernandez Ramos.
Buenos días. That's jail.
Back,
You are on bond for a DWI. You signed an affidavit with me promising me that you would not drive.
America.
And now you've picked up a new DWI.
¿Puedo hablar o no?
Can I speak or no?
You're going to do probable cause in the case. You have the right to remain silent. A can will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Necesitaría uno, señor. Está bien.
Not a problem.
Thank you, Judge.
Piensa.
Judge, on May 4th, 2025, officers were at a Shell gas station and observed the defendant near the driver door of his vehicle and observed what appeared to be an open container in a black plastic bag on the center console of the truck. The defendant was visibly intoxicated with unsteady gait, balance, and almost fell attempting to enter his vehicle. Law enforcement officer advised the defendant in Spanish it was probably not a good idea for him to enter his vehicle in his condition, which he acknowledged and did not enter the truck. Once officers returned to their vehicle, officers observed the defendant in the driver's seat of the pickup truck and was seen turning the vehicle on. Officers at this time began a DUI investigation and observed the odor of alcoholic beverage on the defendant's person and breath. The defendant also had poor balance and gait and was having to lean on his vehicle for proper balance. The defendant spoke in slurred Spanish and when asked, admitted to drinking prior to driving. The defendant stated he had drunk two 12-ounce beers at home prior to arriving at the gas station and had only eaten tacos at approximately 12 p.m. earlier in the day. This time, upon observing the inside of the vehicle, there was no container found of 32-ounce Modelo bottles that was cold to the touch. The law enforcement officer then carried out standardized field sobriety test and observed 6 out of 6 clues on the HGN, 6 out of 8 clues on the walk and turn, and 3 out of 4 clues on one leg stand.
Question. Sorry, I read that.
The defendant consented to a breath test in .185 and .186.
Where was this? I'm pretty sure you said it. I just.
Shell gas station?
In Harris County, Texas.
Mr. Hernandez, let me express my deep disappointment with you. Not only did you promise me when you picked up the first DWI that you would not drive, not only did you promise me that you would not allegedly consume alcohol, not only last time, like this time, have alcohol in the car while allegedly driving. I would presume that it's damn elementary that you're not to have alcohol in the car while you are driving. Anything you say to me will go in one ear and will go out the other, because I know, given the facts, you refuse to comply with bond conditions. As a result, I am now revoking your bond on the first case and I'm setting it at $25,000. And on your second case, I will do the same. I think that you are a deep and utter danger to our county, and nothing will protect our citizens from you other than jail. I don't know if you are going to get out. If you do, you were ordered to remain under house confinement. You will have a GPS monitor on your ankle on one, and on your other ankle, you will get a SCRAM device so I know that you're not consuming alcohol. I am now going to decide whether I'm going to have a contempt hearing, because now you could be facing an additional 6 months in jail for violating, or perhaps violating, this affidavit that you signed promising us you're not going to drive. I'm now also ordering you not to drive any vehicle that's not equipped with an ignition interlock. I'm sending notice to DPS in Austin so that every single officer in the state will know if you are caught in a vehicle, it must have an interlock. And if they catch you in a vehicle and it doesn't have an interlock driving, then you will go to jail. Anything that you want to add?
No, Judge.
Anything from the state?
Nothing, Judge.
Okay. All right, Mr. Hernandez, we'll have you come up, swear to us that you're not going to drive again with the new case, and then we'll put you back. Thanks.
Thank you, Judge.
So let's do both at 25,002.
Settings.
The way to four pending projects.
We have given him
Some
4
light.
PR bonds on these cases.
Now, witness the precise
4
and final
PR
words of
bonds
his
we've
appeal.
given you on these
No
cases,
more
Mr.
delays
Mary.
will be tolerated. Is there still one last
And you
chance
continually
to change the course of fate?
fail
Watch as the pressure
appear.
rises and see what decision shakes the courtroom.
Yeah, can we get a trial setting for Mr. Musaddiq?
100%. Happy to do it. But, you know, the 4 cases, I ordered him to get a GPS, just, they didn't even get it. It's like it's, at what point do we say when? We continually just,
And I have another case that's not on the court's docket for today that I'd like to approach on. It's a John Mary. Mr. Mary's bond was forfeited last week because he failed to appeal. And Mr. Mary is here today in court.
what did happen, please? Did a clock number?
Sir?
Did a clock number?
Yeah, Mr. Mary.
Damn, Blossom, what's up? Too many cruises, man.
Said she was giving me case number and made joke.
I have a case number for you, young.
Counselor,
Please.
do you want to sign up here?
It is 255-211.
255.
2110.
No, this is for, the one you did.
And I prepared a bail order, Your Honor, that I gave up earlier.
I've been working on it. I'm sorry. He told me to get it out.
I told you to show up to court. I told you not to be a danger to my community. I told you to follow the bond conditions, and you have failed to do any of those things, Mr. Mary. You pick up a theft, you pick up another theft, and you repeatedly fail to appear for court. Not just once, not just twice, thrice. Counsel, tell me what you would like.
Your Honor, I'm requesting, that Mr. Mary's bond be reinstated or conditions to be more intense. Mr. Mary has had issues with vehicle trouble getting to court on his days. Now, and I know that that's not an excuse because there are other ways that he could possibly get here, but that has been his particular issue. Prior to him picking up these theft cases, now he has been employed, he has been working, but he's been having transportation issues, John. Now, he's not on docket today, but he is here today to throw himself upon the court to say, Your Honor, he's willing to come to court. He just has issues with transportation and making here, on certain times. The state did make an offer for him on one of the settings.
We have given him 4 PR bonds on these cases. 4 PR bonds we've given you on these cases, Mr. Mary. And you continually fail to appear. Here's what I'm going to do with you, Mr. Unpelon. What we'll do is I'm going to send him for a drug and alcohol test right now. And then we will put this case back on for tomorrow. And I want you tested. And I want to know what, if anything, is in your system. And we will go from there. If you fail to test, if you fail to show up, if you fail to come back tomorrow, it's probably not going to go well for you. Do you understand?
Yes, sir.
I want you to go take a drug test right now. And I'm going to reinstate the bond for the limited purpose of sending him for a drug test now. And then you're to come back tomorrow. And then we will talk about the results and we will talk about your bond tomorrow. You understand?
Yes, sir.
Take a seat, please, sir.
Thank you, Your Honor. May I make some? Yes.